In Penal Code Section 211, California law defines robbery as taking property from the immediate possession of another person accomplished by means of force or fear. So it's a situation like a mugging or a holdup where you use violence or the threat of violence in order to coerce somebody to give you their property.
What distinguishes robbery from just an ordinary theft is force or fear, either use of violence or threat of violence. And that's what makes robbery a much more serious crime than just an ordinary theft.
Usually that means that the property is in their possession or immediate vicinity, but they don't necessarily have to be the owner of that property. I could be borrowing my friend's purse and somebody could come mug me for that purse. Even though I don't own it, the person would still be liable for robbery.
The law says that robbery is a crime that continues until the person reaches a place of temporary safety. And what that means is that if you commit just a theft, but in the course of trying to get away, you use force or fear against a person, then that escalates that theft into robbery. Here in California, we call this an Estes robbery, after a famous case, People versus Estes. And to give you an example, suppose I go and do what's commonly called a beer run at 7-Eleven. So I get a 6-pack of beer, I go up to the counter like I'm going to pay for it, but all of a sudden I turn around and dash out the door without paying for it. Now, at that point, what I've committed is a petty theft, maybe a burglary. But suppose that clerk jumps over the counter, takes off after me, chases after me, and I turn around and I punch that clerk in the face to get him off my tail. At that point, I've used force to accomplish my getaway. And so that simple crime of theft has elevated to the much more serious crime of robbery.
Robbery is always a felony in California, and it's also a strike under California 3 strikes law. If convicted of a robbery, you face up to 5 years in state prison. However, California has a 10-20 life sentencing enhancement for using a gun in the commission of certain crimes. So what this means for a robbery case is that if you commit a robbery and you point a gun at someone in the course of that robbery, but you don't even fire it, that adds an automatic 10 years onto that sentence. If you fire a warning shot and that doesn't even hit anybody, that adds an automatic 20 years. If you fire a gun and you shoot somebody, now that adds an automatic 25 years to life. So you can see how using a gun dramatically increases the prison time in a robbery case.
Robbery is one of those crimes where a lot of innocent people get wrongly accused. The good news is that here at Shouse Law Group, we have a great record of success in defending clients accused of robbery, and ultimately helping them in getting their charges reduced or dismissed.
One of the most common defenses in a robbery case is misidentification. And the fact is that mistaken eyewitness identification is the number one reason why innocent people get wrongly accused and wrongly convicted of crimes across the United States. And it's certainly true in robbery cases. One of the reasons is that robberies are almost always these abrupt, startling events. And usually there's a weapon involved, a gun, a knife, a baseball bat. And when there is, the victims and the witnesses have a tendency to fixate on the weapon as opposed to the face of the perpetrator. So you have a situation where, because of the weapon's focus, people don't get a good look at the face of the actual robber. And because of the stress and the chaos of the event, people's mental faculties are not working well. And consequently, when you take these witnesses to a live lineup or show them a 6-pack photo lineup or a show up on the street, they have a real tendency to point to the wrong person and say, yeah, that looks like the guy. And the tragedy is that this has resulted in thousands and thousands of innocent people being wrongfully convicted and wrongly sent to prison.
Another defense to a robbery charge would be that you didn't use force or fear to accomplish the taking, thus it's not a robbery. Now, for example, say you see a woman in the park and you knock her to the ground and take her purse and run off. Now that would be a robbery because you used force to accomplish the taking of her purse. Now say you go up to another woman in the park and you go up to her and say, "Give me your purse or I'll shoot you." That would be a robbery because you used fear to accomplish the taking of her purse. Now say you go up to a third woman in the park and you just grab the purse out of her hand and run off. This is probably not a robbery because you didn't use any more force than it took just to grab the item. There was no violence or threats used. Therefore, it may be a theft from a person, but it's not the more serious crime of a robbery.
Another common defense in a robbery case is what we call claim of right. What that means is if you have an honest and good faith belief that the property is yours, you can use reasonable force to retake it. Suppose somebody stole my bicycle, and one day I see them riding down the street on it. I can go up to them and retake my property even if I have to struggle to get it back.
One defense that we've had a lot of success with is asserting that our client was just merely present and not actually in on the robbery. He may have been just hanging out with some guys on the street and his friends just decided to rob somebody, but it was not our client's idea and he did not participate in the robbery. He was just in the wrong place at the wrong time with the wrong company. In this situation, he should not be held liable for robbery because the prosecutor has to prove not just he was there, but that he also was an active participant.
Sometimes in a robbery case, the evidence against our client is just irrefutable. Maybe they have him on camera. Maybe he confesses. Maybe there's not much of a defense that we can wage on the facts and the merits of the case. But even in those situations, a lot of times we can work out a deal with the prosecutor and the judge to reduce the charge to something substantially less, like a grand theft person or even a petty theft. We had a case recently where a young lady was facing a robbery charge that could have involved substantial time in the hall and having a strike on her record because she was already 16. But we were able to point out some issues with the credibility of the witness and the fact that the victim was not injured, and ultimately convince the prosecutor to reduce the charge to a petty theft. And by doing this, we were able to prevent our client from having a strike on her record, to prevent her from having a felony on her record that could have marred her for the rest of her life, and prevent her from going to juvenile hall.